Morning.
Good morning, all. We are here for a hearing in the matter CFI 044-2018 before His Excellency Justice Shamlan and Sawalehi. The applicant is represented by Clyde Co. Lead counsel is Rupert Reed QC. Assisting is Keith Hutchinsons and Mohammed Mahmood. The respondent is represented by HFW. Lead counsel is Benjamin Berger. Assisting is Sarah Sheffield and Derek Bailey.
Okay, just before we start, I just a little bit confused with what the main application for today is. From my reading and my understanding from the applicant, he want to hear today first the joinder application, then just the jurisdiction part of the argument, let's say. Now, it's not clear for me from the respondent, the claimant, this is the agreement between both parties, or we have disagree in this? This is where my confusion came.
Well, as you will have seen, we have two applications being made in both the September application notice and the January application notice. It's essentially an application for joinder, but also an application on jurisdiction.
Yes.
I mean, I should just say, regrettably, the two issues aren't as easy to divide as one might hope, because as with last time, where we were dealing with setting aside default judgment,
Right.
and the no jurisdiction defence was relevant to the merits of the case that we were seeking to resurrect by setting aside default judgment. So in this case, the issue of jurisdiction is relevant to the issue of joinder, because clearly one has to decide whether it's desirable to join the applicant in view of the issues that arise in proceedings. So we say jurisdiction is going to have to be dealt with today by myself anyway. Whether your Lordship then goes on and makes a finding, we will say your Lordship should. I understand Mr. Bogue's position to be that you shouldn't. He's handed me a copy of a letter.
My Lord, I don't know if you've had a
I
copy
don't
of
think
that.
this is an attempt to open the application, and I'm sure Mr. Bogue can make these points by way of submission.
Well, just dealing with your point, my Lord, the first question you made, it's a fundamental disagreement about the purpose and scope of today. You've probably seen, if you've had an opportunity of reading the Scottish argument, that the claimant sees it in two separate and distinct areas. One, the joinder application, which your Lordship has properly identified, and I concur with my learned friend, to the extent that jurisdiction is an issue to Regulation 20 will have to be considered. But the fundamental fault line is if there's consideration of jurisdiction under that matter, it has a significant effect on whether there should be jurisdiction of the underlying substantive claim. And the fallacy in relation to dealing with them both at the same time is, on the one hand, the applicant is seeking to say, yes, there is jurisdiction to have the claim, to become a defendant, to then make a Part 12 claim, to say application, to say there's no jurisdiction. And that is a fundamental inconsistency and lack of clarity. So that's why, in my submission, there has to be two separate and distinct applications to deal with this. If your Lordship isn't with the claimant in relation to the joinder application, then the parties can come back and deal with the issues of jurisdiction in the context of the findings you make about the applicant's ability to have jurisdiction. Just in summary on that point is, if there is no jurisdiction, and no doubt my learned friend's going to refer to this, if there is no jurisdiction for the substantive claim, there is nothing to join to. But what the claimant, the applicant is seeking to do is merge them all as one and say, well, Judge, deal with this confusing hodgepodge of an application. It's my firm submission that they should be dealt with separately and distinct.
Well, for me, it's a different strategy a little bit. What I'm worried about is to what extent the claimant, being the respondent in this application, is ready to argue about the jurisdiction today.
Well,
and if not ready, what's the problem? Why is not?
My Lord, can I jump
This
in
is
at
the
that
point.
stage and
Yeah.
say, if your Lordship remember, I'm not going to go to the transcript, but if your Lordship remembers, last time there were issues, firstly, as to which gateway was being relied on by the Prime. It was just said 5A1, no identification A, B, C, D, E.
Yeah.
And that was felt to be unsatisfactory. And it was, I entirely understand the court's position that the claimant should have the opportunity to go away and prepare its position on jurisdiction, and that's what's happened. They've had 5 months to prepare their case and plead their case on jurisdiction. And the other point, your Lordship will remember, is that there was an issue in jurisdiction as to whether this court was the appropriate court, the DIFC court, to be dealing with an application or a claim to wind up a JAFSA company. And that was the point, the jurisdiction point that your Lordship had very much in the front of your Lordship's mind. That was the point that you effectively invited the claimant to deal with over the last 5 months, in which we say they haven't dealt with it. Now, we will develop the submission that they have not dealt with it deliberately, precisely to set up this submission that we're not really in a position to deal with it today, and the court, therefore, isn't in a position to deal with it today. And that's why we say they've had the opportunity. They may or may not have taken it, but the court can now deal with the jurisdiction issue today.
Right. So,
my Lord, can I just
Yes.
reply to that? To the extent my learned friend is saying that the claimant was invited to do so, what the claimant was invited to do was follow the terms of your order from December. And your terms of your order from December set out 3 particular steps. 1, to reserve. 2, if as so far as appropriate, for the applicant to make an application for the joiner. And 3, separately and distinctly, to make any applications in relation to jurisdiction. We're dealing with the second phase now. And that's not, as my learned friend is saying, having this opportunity to engage with the matter. Now, dealing with your Lordship's point, are we ready to deal with it in relation to jurisdiction? The point is, it's a fundamental point, is if there is a joinder of a claim, it's a joinder of a substantive claim. So the reason why it's important, in my submission, for them to be separate and distinct is for the claimant to be able to argue, if you find against us in relation to jurisdiction, that the applicant is bound by the jurisdiction in relation to the substantive claim that it's going to argue in relation to the matter. There's a sequential domino effect of applications that need to be made following your conclusions from the evidence. So that's why it's a fundamental fault line between what we're here and the scope is to deal with today. I'll make it quite clear in relation to the submissions that we've made. It's not evading the issue, it's following your particular judgment from December.
all right. So let's start with the first part of the application, the joint application. Then we'll give my indication by mid of day. Then we'll see how it goes with the second part.
Sure, my Lord.
Yeah, please.
In terms of housekeeping, my Lord, you should have bundles 1 to 3 from last time round. Bundle 1 is essentially a core bundle, I can call it that.
Yeah.
And there is bundle 4, which I think was Miss Sheffield's most recent witness statement, but I think that found its way into bundle 5 anyway, so you can safely ignore bundle 4, and then I will be taking your Lordship to bundle 5, certain amount, which is essentially the new bundle, which adds to the hearing bundle that you had last time. So I don't know if your Lordship has bundle 5 to hand. It's sort of thick. It's probably yours is spiral.
That's only on 4.
Yes, 4 is a slim one, which you can safely ignore. 5 is the one which I'm going to be referring to a fair amount. It's a fairly thick bundle. Hearing bundle volume 5.
Okay. Now, okay, that's it. All right.
And then in terms of authorities, we have the authorities bundles from last time. We have an additional authorities bundle served by the claimant.
Yes.
And then there was an additional authority from my side, which should have been lodged with my skeleton, which is essentially some commentary on CPR 19.2.
Right.
As I trailed in my discussion with my learned friend, there are 2 applications before the court. The first is to be joined for the primary purpose of contesting jurisdiction, and the second application is an application for a declaration that the court has no jurisdiction, or the court should not exercise any jurisdiction that it has. As we've said, the court invited Sunteck to make that application in the December order made on the 27th of December. I'm sure I don't need to take you to it, but just for your lordship's note, that is behind tab 1 in bundle 5.
Okay.
And I don't
Yes.
take you the detail of that, but in terms of joinder, we say the test is one ultimately of desirability, and desirability has to be analysed in two ways. First of all, resolving the existing issues between the existing parties, but also desirability in terms of resolving a new issue with a new party. So does the existing dispute help assist in the resolution of issues between the existing party and the new party? And on jurisdiction, again, our case is very simple. We say there is no possible 5A1 basis for jurisdiction. They don't even, the other side, the claimant don't even identify a particular gateway. This is a dispute about a joint venture company, which is a JAFSA company. Both parties are Dubai onshore companies, and we say it is for the UAE courts to deal with the winding up of a JAFSA company. A second string, so we can win on either string. Second string is that there is an opt-out in the arbitration provision. The parties agreed in the JVA, joint venture agreement, that their differences would be resolved in an LCA arbitration in Singapore. So that's the lie of the land. Now, your lordship will have a fairly good grasp of the background, having heard this matter back in November last year. It concerns a joint venture for construction of a tower in Burj Khalifa in the master plan. That, as we all know, is not in the DIFC. The DIFC don't extend some considerable distance to take in Burj Khalifa. The joint venture is clearly in dispute. At the heart of that dispute is the issue of the contributions to be made by the parties. So the claimant contributes land, an issue about valuation of land, and the applicant is required to contribute and to make financial contributions. And we see in the JVA a detailed regime provisions in respect of the funding obligations of the parties. Ms. Sheffield provides a very useful summary. That's in bundle 1 from last time round. If I could take your lordship quickly to tab 23. In bundle 1.
Yes.
And if your lordship could turn to page 235, paragraph 16, we're dealing with the respective obligations of the claimants, Grand Valley and Sunteck. And I can invite your lordship just to quickly read little a. 1, 2 and 3, that sets out the detailed provisions in respect to the contributions. And I think my learned friend and Skeleton last time round referred to these as carefully drafted. The source of those provisions is the joint venture agreement, although they are transposed, in my learned friend's words, into the memorandum and arts. Now, Grand Valley's case is set out in the same divider at page 236.
236?
236. So if one turns on a page,
Yep.
you see essentially what Grand Valley's case is. So starting at paragraph 19, I'm informed by the claimant that Sunteck, on the other hand, has today contributed only 19.4 million dirham towards the 245 million dirham shareholder loan it was required to contribute. I'm informed by the claimant that the majority of the amount contributed by Sunteck in July 2015 was by way of payment of the transfer fee. It was applicable in respect to the transfer of the land from the claimant to the defendant. An interesting use of language in the I am informed that. So this isn't direct evidence from a witness as such, it's lawyer evidence as to what they have been instructed. Then at paragraph 21, I'm informed by the claimant that as a result of Sunteck's failure to make its required contributions, the claimant has made additional contributions beyond those envisaged by the JV Company's Memorandum in Arts in order to cover the JVCO's commercial expenses, including, for example, rental payments in respect to premises occupied by Sunteck, and payments to cover construction, infrastructure, design, and consultancy, architectural service fees, totaling in the region of 2.98 million dirham odd, which are recorded in the JV Company's books as a debt owed to the claimant. As at 31st of March 2018, the JV Company owed third-party debtors amounts in excess of 61.1 million dirham. As a result of Sunteck's failure to date to adhere to its financial and non-financial obligations under the Defendants Articles of Association, the defendant JV Company is in an extremely perilous financial position. It's apparent to the claimant that Sunteck is neither willing nor commercially able to inject further cash into the defendant to advance its intended commercial activities and purposes. So there have been additional costs, and there has been a dispute as to whether those additional costs come within Sunteck's financial obligations to make financial contribution. That, we say, is at the heart of this dispute. It is a factual dispute which we say should be resolved under the Singaporean arbitration. And your Lordship will remember Clause 36, which is the Singapore arbitration provision in that agreement. In fact, one only needs to turn back one tab to tab 22 in the same bundle, where one has, at the beginning of tab 22, the joint venture agreement, and clause 36 is at page 97. I don't think we need to read through it again. Your Lordship will remember, but for your Lordship's note, that is where clause 36 is found, and 36.3, and the second tier, if you like, of the dispute resolution procedure. It is agreed that the same shall be referred to and finally resolved by arbitration in accordance with the LCIA rules in force, and unless otherwise agreed, the seat of the arbitration shall be Singapore. And our background submission, if you like, is that that is now what needs to happen. The dispute is very fully pleaded in the request for arbitration and the response for arbitration, which your Lordship has in Bundle 5. And that arbitration should now proceed to get on with dealing with the underlying factual disputes about the value of the property for the purpose of the assessment of the Grand Valley's contribution and the sufficiency or otherwise of the contribution made by Sunteck. What one sees instead from the claimant are various strategies which we say are designed to sidestep Clause 36. Your Lordship will be aware of the background. The first strategy was an attempt to forfeit shares that were held in escrow. So there's an entirely separate agreement, an escrow agreement, and that was used to try and essentially grab control of the joint venture company, which owns the valuable property. The escrow agent is ATCO, Al-Tamimi and Company, which I'll refer to as ATCO, which has a Dubai office. And essentially there was a forfeiture provision which meant that if Grand Valley served a long stop date notice, and if Sunteck could not show that it had complied with its contribution obligations, then shares would be forfeited, and then essentially Grand Valley could take control, because it was a 50-50 share ownership, so obviously if they forfeit any shares, then Grand Valley would take control of the joint venture company. And there were two attempts made at that. The first is at page 157, still behind tab 22. So if your Lordship could quickly turn to page 157. So this is a long stop date notice, essentially. So saying to Sunteck, or essentially a notice on Mr. Jody War, who's an Al-Tamimi partner in the DIFC, a banking partner in the DIFC.
I think we're not on the same page.
Sorry, page 157, behind tab 22, still in bundle 1.
Yeah, tab 22.
22. I'm still behind tab 22.
And the page number
Page number 157.
157. Yes, thank you.
So this is a notice to the escrow agent, Mr. Jody War, Al-Tamimi and Company, in the DIFC. Serving notice. We confirm the long stop date, and they have defaulted. Sunteck has defaulted in meeting its funding obligation. And then over page 158, the new paragraph. In the circumstances, we hereby invoke our rights under the escrow agreement and request ATCO to release the documents on expiry of the notice period. So they had an attempt to claim failure to pay the contributions. It's worth quickly looking at 159, because the obligations were to fund the contractor. Now, the curiosity in this case is no contractor had actually been appointed. The fees that are said that ought to have been paid are not contractor fees. If one looks at page 159, one looks at the third column in that table, the expenses are consultancy fees, design fees, supervision fees, sub-consultancy fees, rent of an Emaar Square office, legal fees, legal translation fees. There are a plethora of fees to a plethora of other professionals and agents who would have been working and performing services for the joint venture company, but they are far from being a contribution to the contractor. So that was their first attempt at a long stop date notice, and then the second one is at page 164. And so this is 10 months later, essentially. So they have another go. This one clearly served an Al-Tamimi in the DIFC as the escrow agent. And the allegation in the core of the letter is that Sunteck has failed to fund payments to contractor. So a little ambiguity there as to whether we're referring to the contractor or a number of other contractors. The agreement amount relates to non-payment of at least 3 notices issued for contractor-related payments. So again, fudging the issue of whether we're talking about the contractor. Precisely, we say, because the contractor had not been appointed. And then concluding that the long stop date has occurred. And then your Lordship will be aware that this matter, Sunteck sought an order from Sir Jeremy Cook. He gave an interim injunction. And that, your Lordship, has at page 165. That was then, in November 2017, on the 15th of November, turned into a full injunction pursuant to an inter-parties hearing in October of 2017. Now, what's interesting, we would say, is that the matter of the entitlement to serve a long stop day notice was not pursued. So, if it had been the case that there had genuinely been a failure on Sunteck's part to make financial contributions, all Grand Valley would have to do is to serve a valid long stop date notice, and insofar as it was met with evidence of compliance, they could seek to rebut that evidence of compliance. They did not follow that because they knew, they did not follow that procedure precisely because they knew that Sunteck had showed that it had complied with the funding obligation. Not least because there had been no contractor appointed, and therefore any breaches of an obligation to pay the contractor were unlikely to succeed. So what did they do? Well, Grand Valley then followed a second stratagem. Having been licking its wounds for 6 months, they brought a claim against the joint venture company in the DIFC court. Now, the genius, if you like, of this strategy was twofold. First of all, the joint venture company was in deadlock. There were 2 directors from each side, and therefore the joint venture company was incapable of giving instructions to a law firm to defend the winding up proceedings that were being pursued in the DIFC court. And the second genius, if you like, of the strategy is that once they had got default judgment, which they thought they would get because of the deadlock provision, essentially they were suing a zombie company, if I can call it One would then they could then trigger the termination provisions in the joint venture agreement. And just to explain that, I need to turn within, again, still within the same tab, to page 90. And if I could take your Lordship briefly to clause 25, termination, page 90.
Yeah.
My Lord.
Yeah, go ahead.
So this agreement shall become effective from the execution date and shall remain in full force and effect until, and then if one scrolls down to little d, the JV company is dissolved and or liquidated by court order.
Yeah.
So the strategy is seek to wind up, dissolve the joint venture company, which has no ability to defend itself. Having then dissolved it, obtained default judgment because it can't defend itself because it's in deadlock. Having then obtained mere default judgment, then you can argue that the joint venture company, that the JVA has been terminated, and that is the mechanism then that you seek to essentially use the liquidation to get the assets, i.e. the property that's held by the joint venture company. Now, to look at the, we have to turn to tab 9 to see the claim brought in the GIC. I'm sure it's a document we've looked at before. Your Lordship may already have marked it up.
Yeah.
You'll recall, so this is the CFI claim form. The claimant is Grand Valley. There are a number of defendants. D1, the first defendant, is the joint venture company. Care of Altamimi and Company, Dubai International Finance Centre. So some attempt to suggest that Altamimi, because Altamimi was in the DIFC, that may be a putative attempt to suggest there's some jurisdiction on the basis that the designated agent is in the DIFC. We can scotch that one from the start. The Altamimi in the DIFC was the escrow agent. It wasn't the designated agent for the purposes of the JVA. The designated agent was Altamimi in the Maze building, which is obviously, again, on Checkside Road and therefore outside the DIFC. That's D1. And then, bizarrely, a claim is also made against D2, Mr. Khetan, and D3, Mr. Mishra. Those are the directors of the joint venture company. There is clearly no basis in terms of breaches of funding obligation to sue those two directors. We say those claims were abusive. They have been discontinued, we say rightly. And then in terms of the brief details of claim at page 17, we can go straight on to 4. The claimant and Sunteck entered into partnership together for the purpose of developing a plot of land, whereas the claimant has adhered to its financial and non-financial obligations for the partnership, including a contribution of a substantial shareholder loan to the first defendant. Sunteck has failed to adhere to its financial and non-financial obligations. In light of the foregoing, the objects and purpose of the claimant's partnership and Sunteck in the defendant company is frustrated, such that the continuation of the partnership no longer remains viable. So one has a claim which is brought against the joint venture company, but also the Sunteck directors of the joint venture company. And also at the heart of the brief details of claim is an allegation of failure to make contribution under the joint venture agreement, failure to adhere to those obligations, and also therefore a frustration of the partnership with Sunteck, and an allegation that the partnership therefore no longer remains viable. And as we discussed last time, when one looks at the top of page 18, law giving rise to the jurisdiction of the DIFC court, 5A1, but no reference to any particular gateway. And so we say at the heart of this action against the zombie joint venture company is an allegation against Sunteck that it's failed to pay its obligations, that it has, in essence, frustrated the partnership, and therefore the joint venture company should be wound up. Sunteck, however, is not sued, and we say that's for two reasons. First, it would be an obvious breach of the arbitration agreement, and secondly, Sunteck would defend the action. So if the strategy is to grab default judgment and then argue termination of the joint venture agreement on the back of that joint default judgment, then joining Sunteck would have frustrated that strategy. So that is why we say the reality of this dispute is a joint venture dispute about contributions between the joint venture partners. And that is why we say, primarily as a matter of jurisdiction, this is a matter for the arbitration in Singapore. We say this is a brazen attempt to avoid the arbitration agreement. We looked on the last occasion at Brookfield Multiplex, the case in which this court accepts that anti-suit injunctions can be made by the court of supervisory jurisdiction, the courts of the seat, in order to defend arbitrations where attempts are made to undermine the arbitration agreement by bringing proceedings in other jurisdictions. We won't go there, but just for your lordship's note, that is in the applicant's authorities bundled behind tab 1, paragraphs 36 to 37. So A/1, paragraphs 36 to 37.
Mm-hmm.
Now, Sunteck, faced with the second strategy, i.e. proceeding against the joint venture company, went to the Singapore courts in accordance with the common law assumptions that were assumed by this court in the Brookfield Multiplex case, and obtained from the Singaporean High Court, Mr. Justice Andrew Ang, an anti-suit injunction order. That is it's a final order, it's not an interim order. It makes a costs order against Grand Valley. The Grand Valley was informed of the application for an anti-suit injunction, but went ahead and made an application for default judgment. It did not attend the hearing in Singapore. It did not seek to oppose the anti-suit injunction in Singapore. And to that extent, it was clearly notified of the application and indeed of the anti-suit injunction in itself. So Grand Valley essentially pressed ahead and obtained default judgment, and that was on the 16th of September 2018, notwithstanding that an anti-suit injunction had been made on the 14th of August 2018 in Singapore by the Singaporean High Court. That is why Sunteck made an application to set aside default judgment, and your lordship will be familiar with the judgment given on the 27th of December last year, the default judgment therefore being set aside. It's worth quickly looking back at that judgment, which is in bundle 5 again, behind tab 1. Your lordship will remember that the applicant was a non-party and therefore, in order to intervene, had to satisfy the requirement in RDC 3633 that it had a direct interest which was affected. And your lordship picks up on that issue at paragraph 18, which is at page 8 in bundle 5. And so picking up at paragraph 18, RDC 3633 states that a person who is not a party but who is directly affected by a judgment or order may apply to have the judgment or order set aside or varied. I accept the principle that the applicant must show that it is directly affected, in that some interest capable of recognition by the law is materially and adversely affected by the judgment or order. The applicant is not currently party to the case and thus would be required to show this in order to proceed with the application set aside. The applicant states it's clearly directly affected by the default judgment that dissolves a company in which it is a 50% shareholder, was obtained in breach of the JV agreement, and results from a breach of the Singapore injunction. As the applicant points out, shareholders are entitled to be heard on an application for a winding up order due to their interest being directly affected. And then if we can go on over page to paragraph 23, and then halfway down that paragraph, instead it's clear to me that the applicant's interest as a 50% shareholder in a company that has now been ordered dissolved without its input and presumably against its wishes qualifies it as being directly affected by the default judgment. Furthermore, the interest and cost provisions of the default judgment may increase the defendant's potential liabilities, which has a direct and adverse effect on the applicant. And then if I can go on to halfway down paragraph 24, sentence beginning thus, Thus, I find that the applicant's material interest in the defendant company has been adversely affected by the default judgment. The applicant acknowledges that perhaps dissolution is not the only remedy and has not had a chance to be heard on other courses of action. The claimant insists that dissolution is the only course of action. However, I do not see how this can be shown without some comments as to the applicant and its interest in the defendant company and the dissolution proceedings. So that is essentially the recognition by the court of the material interest of the applicant, that's to say Sunteck, in the joint venture company, and the fact that its interest is likely to be or may be adversely affected, such that the court should hear submissions from Sunteck. And then that leads to the findings which I refer to in the skeleton at paragraph 29 of the judgment.
Yes.
So paragraph 29 begins, thus I am left to assess the application pursuant to RDC 14.22a to see if it appears to the court there is some other good reason why the default judgment should be set aside. In this matter, I find that the applicant who is permitted to make the application pursuant to RDC 3633 has shown that there is good reason why the default judgment should be set aside. This has been shown for a number of reasons, namely that A, there is a question as to the GIC court's jurisdiction over the matter, and I referred in opening to the difficulties, firstly as to whether there was a gateway even identified, let alone shown, and secondly the issue of whether this court has jurisdiction to wind up a UAE onshore company, specifically in this case a JAFSA company. B, there is an interested party that seek to be joined and heard in the matter. C, there's an interested party whose interests are directly affected and was unable to participate in the merits of this dispute. And D, there is some question as to the proper service of the claim on the defendant. Pausing there, looking at A, B and C, we say, although we didn't get to the line in terms of showing that we were entitled to be joined, and although you wanted to give Grand Valley an opportunity to make its case in respect of joinder and jurisdiction, we say the court is halfway there in terms of desirability as a joinder, because the court is accepting clearly in paragraph 29 that Sunteck has an interest in the action being brought to wind up the joint venture company, wishes to seek to be joined and to be heard in the matter, and is unable to participate because of the issue about the deadlock in the joint venture company. So we say the findings made there at paragraph 29 are a very good starting point, we say, for the application made for joinder. Clearly, my learned friend is entitled to say that Sunteck is appealing or is further seeking permission to appeal in respect of those findings. But there's been no application made for a stay of the applications for joinder and on jurisdiction. And your Lordship will also be aware that permission has been refused by yourself, by your Lordship, and that one has behind tab 2 in bundle 5. We say that any appeal, we agree with the findings that there are no reasonable real prospects of success on appeal, and in circumstances where the claimant cannot even seek a stay of the applications made, we say that the court should proceed on the basis of its existing findings made after a full hearing back in November last year, which remain the findings and indeed the order of the court. What this court essentially did, we say, is to invite Grand Valley to plead its case, to invite Grand Valley to explain what its position was on the jurisdiction issues and the joinder issues. And of course, jurisdiction and joinder are very closely linked, because we say we want to be joined in the first instance to challenge jurisdiction. And if one looks at paragraph 30 of the judgment, furthermore, I have concerns about the DIFC court's ability to grant the remedy sought under UAE federal law, and I have not yet been convinced by the claimant that the remedy is permitted in this forum. I understand the claimant contends that there are no merits of this dispute, and instead it's simply a statutory claim without a relevant dispute. However, as mentioned, there is question as to the availability of relief requested pursuant to the statute in question, and furthermore, a judge should determine whether there are merits to the case in light of the attempts of the applicant to join the dispute. So that, if you like, is the invitation to Grand Valley, to the claimant, to set out its stall as to why the GIC court would have jurisdiction in the face of UAE federal law, which suggests that if you're winding up a company, you go to the courts of the jurisdiction in which the company has been incorporated. Now that's the invitation. We say the claimant has not taken that invitation. Your Lordship will have seen Ms. Sheffield's fourth witness statement on jurisdiction. It says almost nothing. A couple of pages towards the back of that witness statement. We say that decision has been taken strategically and deliberately, and one gets a strong sense of that if one looks at the response in the arbitration, where these jurisdiction issues are trailed at great length and with great legal sophistication. So in that context, to merely make a couple of token points in a couple of pages of a witness statement is, if you like, a rejection of the invitation offered by the court to explain how they said that the DIFC court on these proceedings has jurisdiction. Now, in terms of the test for joinder, it's set out in RDC 20. It may be familiar to your Lordship. Essentially, there are two key provisions. There's 2011, which explains that the court's permission is required. The court's permission is required to remove add or substitute party unless the claim form has not been served. And then the test that the court, on an application for permission, has to apply is set out at 20.7. The court may order a person to be added as a new party if, and then 1, it's desirable to add the new party so the court can resolve all the matters in dispute in the proceedings, or 2, there's an issue involving a new party, an existing party, which is connected to the matters in dispute in the proceedings, and it is desirable to add the new party so that the court can resolve that issue. So you look at whether the new party can assist in dealing with existing issues, and you look at whether the existing dispute can assist in resolving the new issues between the new party and the existing party. So the test is essentially one of desirability. Now, desirability is obviously a very broad term. Is it desirable that Sunteck be brought into this case? Now, in terms of desirable to what end, one has the assistance of the Pablo Starr case. And if I could take you quickly to that, that's in the Claimant's Authorities bundle behind tab 2. And then if you could turn on, my Lord, to paragraph 60.
Paragraph?
60, my Lord, bottom of page 14.
Yes.
In considering whether or not it's desirable to add a new party pursuant to CPR 19.2, which is the analogous provision in the English CPR, 2 lodestars are the policy objective of enabling parties to be heard if their rights may be affected by a decision in the case, and the overriding objective in CPR Part 1. Important practical considerations for strictly limiting the circumstances in which third parties are joined to applications to restore a company register, and they apply to applications to set aside an order for restoration. Don't think we really need the rest. So essentially there are 2 lodestars. I think a lodestar is like the northern star. It's the star that doesn't move during the course of the night, if one's in the northern hemisphere. These are the fundamentals, if you like. The first is whether a party has a right that may be affected. That party should be heard. Now, we say that is precisely what one has in this case, and that is precisely the preliminary findings that Your Lordship made on an interim basis in setting aside default judgment. That finding is subject to appeal, but for the time being, permission has been refused. For the time being, that finding is the finding of this court, and we say it applies just as much on our joinder application as it did in setting aside default judgment. Or the second lodestar is the overriding objective, and the overriding objective is, of course, to deal with a case justly at proportionate cost. Now, Your Lordship will be aware the costs in this case, the amounts in issue in this case are very substantial. You're talking about allegations of financial contributions of hundreds of millions of dirhams. So the suggestion that joining in Sunteck would be disproportionate in terms of the additional cost, we say would obviously be a bad submission, even if it were being made. In terms of justice, in terms of whether it's just that Sunteck, whose interests are directly affected, should be joined, we say it is obviously just that Sunteck should be allowed to be a party to defend the interests of the joint venture company. And one can turn around the question of desirability. One can say, how could it possibly be desirable for Grand Valley's claims regarding contributions to proceed against a zombie company, a company that's in deadlock, that's unable to instruct lawyers, unable to defend itself, with the real defendant, Sunteck, the pleaded defendant, Sunteck alleged to have failed in breach of its contribution obligations, excluded from those proceedings? How could that be desirable? That, if you like, is the question that Mr. Berger, my learned friend, has to answer in his submissions. Of course it's not desirable. Those are entirely contrived proceedings. The issue of whether Sunteck failed to make contributions arises squarely, we say, in the Singaporean arbitration, which is the forum agreed by the parties. The purpose of joinder, we say, is twofold. Firstly, in the first instance, to allow Sunteck to make the defence that the GGICO court has no jurisdiction to be winding up a JAFSA company. We say it's clearly connected to the matters in dispute, and the court has expressed sympathy with that issue of jurisdiction. The court has explained that there are concerns about jurisdiction in setting aside in the set-aside default judgment hearing. We say that Grand Valley has had the opportunity to make good its arguments of jurisdiction, to explain to this court why it says it has jurisdiction by reference to a gateway, by reference to the relevant UAE statutes. They have not taken up that opportunity. They are still alleging merely 5A1 jurisdiction without any reference to any particular gateway. They have failed to articulate any coherent argument in respect to Clause 36 and why they say this is not a dispute between joint venture parties which comes within the arbitration group, which is, if you like, the second string, an opt-out. So we can show there's no jurisdiction, even if they were now able to identify a gateway and were now able to establish that they came within that gateway, there would still be the opt-out. So we can succeed in jurisdiction on either our first line of argument or alternatively our second line of argument. And we say it's clearly desirable that the court should have the benefit of argument from Sunteck on the jurisdiction issues. And that, we say, is why this is a case of 20.72 joinder, because the issue is an issue between Sunteck as a new party and Grand Valley as the existing party. And secondly, even if the court were to find that there were jurisdiction, that Grand Valley had jurisdiction to bring its claims, even if the court found jurisdiction, there are still substantive defences, the pleading that there were failures to make funding contributions, the underlying issues, if you like. And we say again, it makes no sense to consider those issues without an active defence from Sunteck. And that, we say, is a 20.71 joinder, being an issue as to contributions, which is already in issue on the pleadings in this DIFC action. It's an allegation that the joint venture company will be unable to defend without the joinder of Sunteck. And as the court accepted in paragraph 29 of the judgment, Sunteck is an interested party which is unable to participate in the debate as to the merits of the underlying claims in respect of the contributions of the parties. So we say on both of those two heads, 27.2, in order to run the no jurisdiction defence, and secondly, on the substantive defence to the allegations of non-contribution, on both of those issues, we say it is plain that the joinder of Sunteck is desirable, and it's entirely undesirable that the court should proceed in the absence of Sunteck. Now, it's worth looking at this point at the objections that are raised to joinder. There was last time a suggestion that there was somehow an election not to challenge jurisdiction, because if we had wanted to challenge jurisdiction, that could have been achieved through the Sunteck directors. I don't think that point's been taken by my learned friend in the skeleton. It was roundly rejected last time round. We would say that the action against the Sunteck directors was abusive, and insofar as that has been discontinued, that we say was the correct decision. And the discontinuance does not prevent the application either for joinder or the second application in respect of jurisdiction. There's also some reference in Ms. Sheffield's fourth statement to the difference between RDC 2011 and 20.7. We say they're essentially the same thing. One sets out the need for permission, and the other sets out the test in order to get permission. But they are essentially referring to the same jurisdiction, the same discretion of the court to permit the joinder of a party on the tests in 20.7. So we say it is of no significance whether reference is made in the relevant application at 20.7 or 20.11. It's clearly referring to the same joinder by permission of the court by reference to the tests in 20.7. The test essentially being one of desirability. In any event, we say it's clear throughout the witness statements and indeed the skeletons, both this time and last, that 20.7 is the test being applied. So if it is still being said that there is a technical objection by reference to the application notice referring to 20.11 and not 20.7, we say that is a meaningless distinction. They are two provisions dealing with the very same issue. Then, and if my learned friend wishes to press this point, then I may need to come back on reply, by way of reply, but for the moment I'm going to leave it there. Then we need to look at a few authorities which are raised by my learned friend in his skeleton. I think for two propositions. The first is that implicitly Sunteck is merely interested in a question of law, and my learned friend refers in his skeleton to the spelling case, which is behind tab 8 in his authorities bundle.
Yeah.
Spelling Goldberg Productions. Sorry, I'm corrected. My friend. Tab 1 in the hearing bundle, page 1, case of Spelling Goldberg Productions in the Court of Appeal, the English Court of Appeal. And you'll see about halfway down the page the first of the two holdings. There was no jurisdiction to allow the Phil companies to intervene since RSC Order 15 Rule 6.2 required this, so this is pre-CPR, it's a 1980 decision. Required there to be a present question or issue between the parties to the appeal and the interveners. The mere possibility that the defenders might in future copy frames from the interveners' films if they were successful in the appeal did not give rise to such a question or issue. And then if one just picks up over page 2, the first hole punch. In my judgment, the construction of that provision gives no difficulty at all, and what is clearly contemplated is a situation in which there already exists a question or issue arising from a decision upon which the rights of the party seeking to intervene in the proceedings may depend. Mr. Prescott has urged upon us that the use of the word may in the phrase may exist a question or issue contemplates the possibility of a future question or issue which might possibly arise between the parties seeking to join in litigation and one or other of the parties already involved in the litigation. But I can see no reason to give that phrase that somewhat, as it seems to me, extravagant construction. Clearly, what is contributed is that at the time when an order for joinder is made under this provision, the question or issues arising out of or relating to or connected with the relief or remedy claimed in the cause already arises between the parties seek to be joined and one or other of the existing parties to litigation. So it's not enough that there's some future issue which may hypothetically arise. There has to be an issue now arising in respect to the new party, which makes it desirable that the new party be joined. As I've said, we say it's absolutely clear that the Sunteck has a present interest now in defending the position of the joint venture company. It's not a future interest, or it's not a hypothetical interest. And to that extent, we say the Spelling case is a case which we have no particular issue, albeit that it's brought in respect to the old regime. It's not a CPR case, it's a test of the RSC. But in any event, the interest of Sunteck in the DFC proceedings is a current, present and real interest as acknowledged in the 27th of December judgment. There also appears to be an implicit submission that Sunteck will merely duplicate submissions of the existing party. So if one looks at two cases which are referred to in the skeleton, first the Lehman Brothers case, but also the XYZ case. In those cases, joinder is rejected because essentially the new party was in exactly the same interest, had exactly the same position as an existing party in the dispute, and therefore there was no benefit in joining the new party because they would be duplicating the submissions of an existing party. And just to make that submission good, if we could turn to the Lehman Brothers, which I think is behind tab 3.
Yes.
And if we could turn to paragraph, go straight to. Yes, if one starts at paragraph 18, the application by limited. So 18, limited, represented by Mr. Philip Marshall, who seeks to be joined to the Intermediate 2 proceedings, where it would support the case made there by Holdings plc and Deutsche Bank. It now has been joined. So if Deutsche Bank has been joined, the question is whether limited should also be joined. It seeks joinder on the following basis. In the little a, it has a strong economic interest which is actually more direct than Deutsche Bank's, whose interests rely on contingencies. B, limited has its own perspective and should not have to rely on others. And going straight to F, like Deutsche Bank, limited is prepared to undertake not to duplicate points taken by others and to bear its own costs. And then if one picks up over page paragraph 22, in the case of limited, I've decided that there should be no joinder. I accept that a strong economic interest exists, but it's insufficient by itself, and I do not accept the other reasons for joining. I repeat what I've said about the lack of conflict in the Holdings plc administrators. Going to 23, with the addition of Deutsche Bank, there will be sufficient number of entities arguing the same interest as limited, and I'm not satisfied that limited has any further point or perspective to contribute. The point about Holdings Incorporated bearing a significant part of the cost through a possible reduction of dividend has some. I am quite satisfied. The fruits of limited administrators' evidential exercise can be made available in a perfectly efficient and sensible manner without joining. Its presentation does not require joining either. And then in paragraph 24, picking up halfway down the paragraph in the sentence beginning, although in complex insolvencies such as Lehman, there are inevitably and regrettably going to have to be some complex proceedings with large numbers of parties. The court has nonetheless to be on its guard to keep representation within proper bounds and only allow in parties whom the court is persuaded do have some separate perspective or legal interest to illuminate to the benefit of the court. So what is being implicitly alleged here is that Sunteck has no interest that's distinct from the JV company's interest. So the court doesn't need to join in Sunteck because it's going to hear the submissions in any event and it's going to understand the perspective of the joint venture company. Well, we say that that's wrong, and the reason that's wrong is because the joint venture company is in deadlock. So the joint venture company is not going to be making any submissions that would be duplicated by Sunteck. It is Sunteck that needs to be joined, that is desired to be joined, desirable to be joined, in order that it can make the submissions both on jurisdiction, and if it fails on jurisdiction, the submissions on the underlying disputes in respect of the contributions made by Sunteck. The other case about duplicating the interests of an existing party is XYZ, which I think is behind tab 6. It's the same authorities bundle. This is a fiendishly complicated case, and no doubt the management will explain some of the detail in due course. But essentially, this case arises out of the class action litigation in respect of breast implants that were found to be faulty and defective. And there were claims against the hospitals that had provided the treatment, and there were also claims, including Transform Medical Group, and there were also claims against the suppliers of the faulty implants. And lurking behind those primary alleged tortfeasors were the relevant primary insurers. And one of the primary insurers sought to join in the insurer of one of the other tortfeasors. And the judge had some fairly interesting things to say as to why that was wrong. So if one picks up paragraph 17, strict to its essentials, Travellers' Commission and Travellers Travellers were insuring Transform, the hospital. So the hospital insurer's position was that sooner or later Amlin, which was the insurer of the suppliers of the implants, will be brought into litigation. It's sensible, Mr. Lockie submits, that it should happen now. The more insurers who are involved in negotiations, the greater the likelihood of an early resolution of these claims. Knowing whether they are likely to be indemnified by me will affect the approach of Travellers and Transform to negotiation. Early settlement is more likely if all of the relevant insurers are involved now. If settlement is not reached, it's desirable that Amlin should be bound by decisions made by the court in respect to insurance policies. That can only be achieved if they are part of the insurance trial. Otherwise, there's a risk of inconsistent decisions. Amlin's position is this: the application is misconceived and anyone premature. There are no issues between the supplier and its insurers. There may never be an issue between Amlin and Travellers or Amlin and Transform. And then the judge's decision relevant decision comes at paragraph 27, bottom of page 65. Bottom of page 65. And this is the decision of Mrs. Justice Thirlwall. However attractively packaged this application may be, it's an attempt by Travellers Transform to establish in advance the depths of another insurer's pockets. So, at bottom of page 65, paragraph 27. So one insurer wants to see another insurer brought into this class action to see how much that other insurer can cough up by way of compensation, which will determine its own approach in the negotiation. If Mr. Lockie's submissions are correct, CDR 19.2 would entitle the claimant in a personal injury case to join into proceedings for defendants' insurers, seeking a declaration as to the scope of the insurance available to meet the claim. So Mrs. Justice Thirlwall is saying, well, if one insurer can bring in another insurer, then any alleged tortfeasor could seek to join in its insurer, or sorry, the claimant could seek to join in the insurer in order to see how much the insurer was going to provide by way of insurance. And then paragraph 28, as to the practical points raised by Mr. Lockie in seeking to join, I make the following observations. And looking at Little Roman 2, if the points that arise in the Amlin Cloverleaf insurance policy are the same as those that arise in the Transform Travellers Spire RSA insurance policy, the conclusions are likely to be the same. There is no need to add further policies to decide the same issues. So we say this case raises exactly the same point as the Lehman Brothers case. There is no point joining in a party if it is going to make precisely the same submissions that another party is already making and going to make. And indeed, in this case, the further point that if it's just about structuring negotiation, that is not what negotiation, that's not what the joinder is about. But we say there is no risk here of duplication. If one is saying, is it desirable that Sunteck be joined in circumstances where the JV company is deadlocked as a zombie company, clearly it is desirable because the right submissions are not otherwise going to be before the court. The fourth objection in Melanie Frank's skeleton, and indeed Miss Sheffield's fourth statement, is the no consent point. In other words, the suggestion that there can only be a joinder of the defendant if the claimant consents. We say that is simply not an issue under 20.7. 20.7 sets out very clearly the criteria on which the court can permit a party to join another party. Presumptively, the other party doesn't want to be joined. That's why the permission is being opposed. And we say the reliance that's placed on the Milton Keynes Borough Council and Vidor case makes it very clear that this is an entirely misconceived argument. That case, Milton Keynes, is behind tab 4 in Melanie Frank's skeleton argument. I have a head note. The head note, I'll just read out the holding from the head note. Holding, application refused. The case was not caught by the joinder provisions in CPR 90.22, and it would not be fair or proportionate to permit the amendments which were made very late, and if they were allowed extensive disclosure to the trial. Until shortly before the pre-trial review, the defendant provided there was no job in this respect of the claim, which in any event remained unclear and explained. Furthermore, it would be a nonsense if the defendant could join another defendant in proceedings against the claimant's wishes in circumstances in which the claimant would then be potentially liable for the costs of a new defendant. So the starting point is there is no case is not caught by 19.2, that's the provision that is analogous to 20.7, and in those circumstances it would be a nonsense that a party would be joined against consent. So one starts with is 19.2 satisfied, or 10.7 in our case? If it isn't, is there consent? So we say this is not a freestanding authority, the fact that a party can't be bound joined to proceedings unless it consents. That would make a nonsense of 19.2 in the English CPR and a nonsense of 10.7 in the rules of the DIFC forward. The joinder is dealt with in a judgment, paragraph 7, the bottom of page 28. Paragraphs in defence, paragraphs as identified. These paragraphs envisage the joinder of VWML as a second defendant to these proceedings. Paragraph 8. I refuse the defendant permission to join the VWML as a defendant and to make the amendments noted above. There are a number of reasons for that. 9. First, I do not consider the court has power to join a party as a defendant in the circumstance where the defendant proposes that joinder. No authorities which such another proposition is cited to me. 10 is the important part, we say. Reference was made to CPR 19.22, which provides as follows. That's essentially the same test that we have in 10.7 this jurisdiction. Then, again, the desirability, both from the perspective of the existing issues and the new issues of the new party. Then 11, the proposed joinder of VWML is not caught by either of these provisions. There is no matter in dispute between the Council and VWML. Indeed, the Council has made a claim that because there is no dispute between these and VWML, it does not wish the VWML to be joined in proceedings as a defendant. Neither is there any pleas issued between VWML and the defendant. So we say at the heart of this case is a finding that the test in 19.2 is not satisfied. and that is very much the thrust of the commentary in the English White Book, and your Lordship will have had hopefully attached to my skeleton some pages from the English White Book. Your Lordship may take a look at the skeleton or file with someone else.
I've seen it.
So it may have made its way into volume 5. We'll just find the reference. I'm told it should be right at the beginning of volume 5. Yes, that's right. The skeleton should have gone in at tab A right at the beginning of volume 5. Does your Lordship have a page that has the White Book?
Yes.
Yes, good. Well, I'm going to go to the commentary, which your Lordship has at page 647. So, and it's 19.2.1. Then I'm going to start at the third paragraph of the commentary under the rubric effect of rule. Nobody can be added or substituted as a claimant unless they give written consent, and that consent has been filed with the court. Rule 19.4.4, see paragraph 19.4.4 below. And then this is where I start highlighting persons can be made defendants against their will and against the will of the claimant or other parties if the court is persuaded as to either of the reasons for adding new parties set out in paragraphs A and B of Rule 19.2.2, as to which see further below, and for further case illustration see below paragraph 19.4.2 concerning interveners. Then there is a helpful commentary on the Milton Keynes case, which will learn and refers to the skeleton. In Milton Keynes and Viridor, concerning a claim for the remedy of rectification of contract made to the claimant defendant's company, the latter sought to add a second defendant company which is subsequently purchased all the shares of the defendant company. The purpose of the joinder was to enable the defence to plead on behalf of its new owner a defence which was not available to the defendant itself. The defendant wished to argue that the new owner was a third party which required an interest in the contract and plead the claim to the defendant without notice of any entitlement the claimant might have to the remedy of rectification of that contract. And critically here, Mr. Justice Coulson dismissed the application to add a second defendant, primarily on the basis that neither of the reasons for adding a new party set out in paragraphs A and B of Rule 19.2.2 had been established. So the commentary in White Book, which is, we say, an authority commentary, makes clear that at the heart of the reasonings of Mr. Justice Coulson is the fact that neither of the conditions in Rule 19.2 were satisfied. And just while we're on this page, if one goes down 3 paragraphs, your Lordship has there the reference to the 2 lodestars. So where the second whole punch is considering whether it's not desirable to add a new party pursuant to 19.2 lodestars of the policy objectives. So that's the point from the star. So again, a useful summary of that reference to the lodestar, the 2 points being: is there a party, is the applicant a party whose rights may be affected by a decision and or be overriding objective? So we say clearly the test is 19.2 or in this jurisdiction 20.7. The test is not just a matter of consent. If the criteria of 19.2 or 10.7 are not satisfied, then clearly consent is going to be highly relevant. But that is not, we say, where we are in this case. We say in this case it's clearly desirable. And lastly, in terms of substantive points, it said that desirability alone is insufficient. These submissions seem to go in a very odd direction. I understand from my friend, your Lordship, and I should have had it at the front of my mind, but your Lordship was actually sitting in the Court of Appeal in the Nest Investments decision of the Court of Appeal handed down on the 13th of March. Now that was a case where it was found by the Court of Appeal that there was necessary and proper party jurisdiction under 5A1E on the back of 20.7. that being a DIC regulation for the purposes of jurisdiction. Now, the issue about whether desirability was sufficient or insufficient, which is the way the Millennium Friend seeks to frame this debate, of course, relates to jurisdiction. Is it sufficient to establish DIC NPP jurisdiction, or is it not sufficient? Now, the first time round, Mr. Justice Roger Giles, in the first Nest Investments case, found that it was insufficient for necessary proper party jurisdiction. He was saying if you could just rely on 20.7 as a basis for necessary proper party jurisdiction, then basically if it was desirable that any party anywhere in the world could be joined, should be joined, then the court would be assuming necessary proper party jurisdiction against that party anywhere in the world on the basis of mere desirability. He said, well, that can't be right. Desirability can't be sufficient on its own. Now, 2 points. Firstly, that's about jurisdiction. It's not about joinder. So if there is jurisdiction, then it's not about the joinder. It's about jurisdiction. And the second point, the more telling point, is that in any event, the Court of Appeal, in its decision of the 13th of March, reversed those findings by Mr. Justice Roger Giles. If your Lordship wants to look at those provisions in the judgment of first instance.
I'm familiar with
yes, good, then I won't. But for your Lordship to note, it's paragraphs 98 and 99 of the first instance decision behind tab 5 in the Claimant Authorities bundle. It was reversed in the Court of Appeal. I don't think I set out in my skeleton the relevant provisions of the Court of Appeal judgment. I think I can extract from the Court of Appeal's judgment a few bold propositions. Firstly, the RDC are DIC regulations for the purpose of 5A1E. Secondly, 20.7 is apt as a matter of construction to confer jurisdiction on the DIC courts. We say in a way that the JAFSA Memorandum of Understanding is not. Thirdly, there are strong reasons of public policy for the GGICO courts to have a NPP, natural proper party jurisdiction. And so, in terms of jurisdiction, what the Court of Appeal essentially found is that desirability under 20.7 is sufficient for the purposes of jurisdiction. But we say that has nothing to do with the issue of joint in itself. That is very much focused on the issue of jurisdiction. And if my learned friend is going to continue to push this point, then I may come back to further detail, but in my submission it's very plain what the relevant sufficiency refers to, and it refers to jurisdiction, not joinder. For the purposes of joinder, it's quite clear that desirability is sufficient, and indeed for the purposes of jurisdiction, it's quite clear that desirability is sufficient. Now, as I said, we are going to make submissions on, with your Lordship's indulgence, on jurisdiction, because we say...
My Lordship, I hesitate to interrupt. My learned friend has been speaking for an hour and 20 minutes, and this was a 3-hour application here. I do have a letter relating to the separate matters that we're dealing with. If my learned friend is going to go on to jurisdiction, that is going to have a significant impact on the time.
I think we agreed to focus in the first round on the certification on the joinder. I think I will give you 5-10 minutes more to just wrap up on this area before we jump to the jurisdiction. We're going to have another time, unless.
Well, we do say, Lord, that we applied in September and we've reapplied in January to deal with the jurisdiction issues.
Yeah, this is something I will decide on after I hear the
okay, and our other point is in terms of the listing, we understand it's been listed for the whole day.
Yeah.
So at lunchtime, if I'm still on my feet, the learned friend will rightly jump.
Well, I understood it was a 3-hour.
That's fine. As much as you can pay for the court, we don't have any mind. We can extend the hours as much as we can until the 5 p.m. But this is something different.
We already have a listing from 10 to 4.
Yeah, this is my understanding.
Your learned associate will know that.
So let's finish with the first part about the joining application, and I'll take 10 minutes break. Then I will hear from your position on the joining.
Just the point.
And I will leave the jurisdiction afterwards. I will decide on.
I'll just take some stock. Well, I'm going to accept your challenge of giving a broad summary for the purposes of the joint application of jurisdiction, but it will just be for 5 or 10 minutes.
Yes, please.
If I may. And if there is joined, and if your Lordship does have time available, we would like to argue jurisdiction issues, because we say the court can conveniently deal with jurisdiction today, assuming joinder. Essentially on jurisdiction, we say there is no problem with being joined in order to challenge jurisdiction. We say that's clear on all of the initial authorities. It's clear in Dicey, it's clear in Briggs, it's clear on all of the tests. We note the absence of any identification of any gateway. There is no party jurisdiction. The designated agent is, we say, ATCO in the Maze building, not in the DIFC. The shares, the escrow shares, if you like, are being held in the DIFC, but that is a matter of the escrow agreement, which has its own provisions in respect of disputes. There are issues about service on the registered agent. The agent is there for purposes of service, but service and jurisdiction are entirely separate issues. One can have a case where there is, for example, subject matter jurisdiction because the contract was concluded in the DIFC, but the question of whether or not the relevant party has been served is an entirely separate question. So we say, as a matter of jurisdiction, there is no party in jurisdiction for the purpose of 5A1A, even if it were alleged. There is no subject matter jurisdiction. There is no connection with the DIFC. The best case that they can make on jurisdiction is the JAFSA Memorandum of Understanding. That, we say, is plainly not a DIFC regulation. Even if it were, it's not one which is apt to confer jurisdiction. And then in terms of UAE law, the suggestion that somehow the Grand Valley has an inalienable statutory right under UAE law to wind up the company, well, that may be right. We say, in any event, it would be a matter for the UAE courts. It's quite clear that as a matter of jurisdictional framework that the DIFC court, so there is an exemption of the DIFC from the civil and commercial laws of the UAE. So this court is not going to be applying or subject to the civil and commercial laws of the UAE. So that point too, we say, fails. And then quickly, in terms of Article 3 and the arbitration law, we say it's clear that the pleading claims are against Sunteck and arise under the joint venture agreement. And there is further the breach of the Singaporean order. Even if it's not binding, we say there are issues of comity, and this court ought to be seeking to cooperate with the Singaporean courts and the order and respect the orders made by the Singaporean courts. We say too, if one looks at the Singaporean arbitration and one looks at the request and the response, there is very detailed argument in respect to jurisdiction that one simply doesn't find in these proceedings, and we say the reason is that forensically, to allow my learned friends to suggest that, well, they're not really yet in a position to argue jurisdiction, and we say that is a matter of forensic choice by the claimant, strategic choice, and that should not be allowed to hold up the jurisdictional issue. It's also suggested that matters of winding up are not susceptible to arbitration, and we say it's entirely clear as a matter of English authority that a tribunal in an arbitration can decide the rights and obligations of the parties, can make a declaration which may bind a liquidator, and can indeed direct a party to bring insolvency proceedings even if it can't in fact affect winding up itself. And we say it's clear that that's what's intended by an arbitration provision in a joint venture company, that the joint venture issues are resolved in an arbitration. If a joint venture company then needs to be wound up, that could then be a matter for the local courts, if that is what is required by the relevant statutes. We say that there are service issues raised as well. We say those are nothing to the point. They're immaterial. In any event, the ASI has now been served, and the Sunteck is still pressing ahead in pursuing its appeal against default judgment. So the argument that the alleged failure to serve the ASI, we say, again, does not advance the claimant's position. There are then various technical points, the suggestion that we needed to make separate applications in separate application notices. We say that makes no sense as a matter of reasonable case management. And the suggestion that there needs to be a further hearing, again, we say makes no sense. They have been given an opportunity and an invitation to explain the gateway on which they rely. They've been given an opportunity to explain how they square the existing proceedings with Clause 36 of the Singaporean arbitration provision. They have failed to do so, and we say the court on jurisdiction should now act to stay the proceedings and bring these games to a close.
Thank you. I think we perhaps will take 5 to 10 minutes break. Let's say 10 minutes break, then we'll come back to hear from the claimant, respondent in this application position, and deciding. That's all. Thank you for that.
All right.
Okay, Mr. Benjamin, please.
I'm grateful, Your Lordship. First, Sumesh and I are going to make this question why we're here.
Yes.
And in order to develop that submission, I'd like to refer to your judgment, Your Lordship, which was made on the 27th of December. It's at tab 1 of volume 5. And there's 3 particular paragraphs that I'll look at for these purposes and explain the approach that has been taken, I'd say, quite properly to today's application.
Yes.
The first is at paragraph 16, Your Lordship. And in your judgment, you decide, while the applicant makes its primary case that it should be joined as a defendant in the matter, the appropriate issue is to consider, as a result of the applicant's application, is first, whether the applicant may make the application, and second, whether the default judgment should be set aside. This is not an appropriate application through which to join a party or contest jurisdiction, so you deal with those matters quite definitively in December that you're not going to deal with. Those issues, you go on to say, Your Lordship, can appropriately be taken up in separate applications with the benefit of full pleadings on the issues. Now, I don't hesitate to exaggerate the importance of those words, especially in the context of my learned friend saying that Your Lordship has implicitly invited the claimant to make representations. Quite the contrary, Your Lordship. You have made clear recommendations, if anything, for the applicant to make appropriate applications through full pleadings and issues. And Your Lordship goes on to say, well, I appreciate the applicant argues that sufficient pleadings have occurred on these matters, such that no further argument is necessary, and the court can make certain findings on its own initiative. I find it is prudent in terms of case and cost management to decide these additional matters in order to allow the claimant the full ability to respond. And if I just pause there, Your Lordship, when we're dealing with the applications of joinder and by submission not dealing with issues of jurisdiction today, we have to have regard to the overriding objective of cost and case management. And the significant factor in this regard is if and only if Your Lordship finds that there is joinder, does then the consideration of joinder into what issue, in relation to what matters, in relation to what areas of dispute are going to be considered. And then that thirdly lies a question as to the appropriate jurisdiction, whether it's under Section 5A, whether it's in connection with UAE law for winding up proceedings. That's paragraph 16, Your Lordship. If I can look also, just to develop what you say in your judgment of paragraph 30. Further develop your assessment where you say, that you have concerns about the DIFE Court's ability to grant the remedy sought under UAE federal law, but you put that as a concern, and you say you've not yet been convinced by the claimant that this remedy is permitted in this forum. I understand that the claimant contends there are no merits of this dispute, and instead is simply a statutory claim without a relevant dispute. I'll just pause there, because that is the assessment which I'll be taking to my learned friend's extensive and detailed exposition of what he says the dispute is by reference to the applicant. Well, I'll be making reference to what the dispute is by reference to the claimant and the defendant. And in my submission, that has to be the crucial assessment in your determination as to whether it was joined today. You go on, Your Lordship, to say paragraph 30, however, as mentioned, there is the availability of relief requested pursuant to the statute in question. A judge should determine whether a merit in light of the attempts of the applicant to join the dispute. So I read that, Your Lordship, of you underlining, firstly, is there a joinder, and then in the light of joinder, is there a jurisdiction to join? And finally, if we look at paragraph 34 of your Lordship's judgment, your Lordship explains again, when dealing with service, nonetheless, this case will benefit from more complete service, as detailed further below, and the opportunity for the applicant to make its cases to join them. I do acknowledge the seemingly contradictory position between seeking to join a claim in order to contest jurisdiction. However, this must be fully pleaded and heard before a claimant can move to remedy. So, Your Lordship, it's not a matter of strategy in relation to the claimant's position today in not dealing with issues of jurisdiction. The application is listed in a 3-hour application notice to deal with, as far as the claimant was concerned, with the first of Your Lordship's orders, which was joined there. And that is going to be forming the focus of my submissions this morning. I'm in agreement with my learned friend when we're dealing with the relevant provisions, and not surprisingly. We're dealing with Regulation 2011 and Regulation 27.2. Where I diverge from my learned friend is the process in which Your Lordship should undertake that assessment under Regulation 27. And just by a matter of headline, first, the most important aspect which my learned friend seems to merge is what's the dispute. If Your Lordship considers the dispute as is set out in the pleadings, and let's just look at that if we can in Volume 1, and it's the sealed claim form, Divider 9.
Should we look to Volume 1?
Divider 9.
Yes.
Whilst my learned friend took you to the particulars in paragraph 4 and 5, what he didn't do is take you to page 18, which is what was the remedy sought, which is effectively the dispute, the objective, the mischief of this litigation. The mischief of this litigation, we can see clearly in the remedy sought. It seeks declarations, and when we look at each and one of these declarations, we have to ask ourselves in our respective submission where, if at all, the applicant teaches. And if it does, whether it is an interest for the purpose of Section 27, which makes it desirable or appropriate to allow to join. So, first aspect in paragraph page 18 is claimant seeks declarations for the dissolution of the first defendant. in accordance with Article 2956 and 298 of UAE Federal Law, number 2 of 2005 concerning commercial companies, and that it's entitled to interest on monies, and that it's paid out in dependent proceeds. It's worth just looking at my learned friend's submissions in relation to the scope of UAE law in the context of the arbitration procedures or Singaporean procedures. What he accepts is it's a paragraph where it says it's for the UAE court to deal with the winding up of a JAFSA company, and just see where he says that. In his opening submission. And if that is right, it is for the UAE court to engage in the winding up proceedings. This is not to do with the Singaporean proceedings, it's not to do with arbitration, it's exclusively reserved of the UAE court. So when dealing with what the mischief of this claim is, it's for the proceeds or any assets or liabilities of the defendant to be properly assessed and distributed. Now, your Lordship did find in the December judgment that that amounted to interest. However, I'll go on to develop that that's a separate, distinct analysis under Rule 36, the one that you must undertake under Rule 20. And the provisions which my learned friend alluded to from my submissions are the matters of the case law, which I'd like to just go through firstly before then looking at the facts of this case. I set out a number of principles that my submission should be at the forefront of your mind when considering the joint of application. And those application issues are consent of the claimant, whether there's a justifiable reason, and that goes in relation to the nature of whether the applicant is a primary or secondary party, whether it's in the interest of justice, i.e. whether the costs and pleadings will be more complicated and necessarily detracted, and finally whether it's appropriate just to apply to deny the court's jurisdiction. So if firstly deal with the case of Spelling Goldberg, and that's at this is the authorities bundle.
Right.
I think it's worth just dwelling on this a little. In this case, there was an application for intervening, as it was then, in the rules of Supreme Court, by a party under the fear that its rights could be undermined in future. And the Court of Appeal in this case held, at paragraph 1 held, that there was no jurisdiction to allow a film company to intervene since there needed to be a present question or issue. And that's what I'd ask you to emphasise, between the parties. And again, that's what I'd ask you to emphasise. The parties in this is the parties between the claimant and the defendant. What my learned friend has done throughout his submissions is he's tried to import the applicant as one and the same as the defendant. And it's my submission that it's important that there is a clear line of distinction between what is the status and the positioning of the applicant in relation to the issues. And the issues are not, they're not what my learned friend says they are. as a result of the request for arbitration. They're not what my learned friend has sought to develop. The issues here are to what extent it's appropriate to wind up this defendant. That's the issue here. And the matters in relation to what my learned friend is suggesting of who's at fault or who's liable for it, they're all matters that can be dealt with in relation to the winding up process. The issue here is monodynamic. It's one issue, and that is to what extent the court is able to consider whether this company should be wound up in accordance with this claim.
So, in your submission, are you suggesting that the winding up or declaration to winding up the defendant, that in anyhow will not affect the applicant?
That's a different aspect, and I'm going to come on to that in relation to affecting isn't the same for the purposes of Regulation 20. Affecting of an interest is not sufficient in my submission. That is a different analysis from Regulation 36, which you've already dealt with. Okay. If I go through the case law, I'll be able to say affecting is clearly not the case, because my learned friend took you to the XYZ case where there was clearly a potentially effect, but that wasn't sufficient. What there needed to be was a consideration of whether it was appropriate in accordance with the provisions of Regulation 20. And I'll ask you to look at those separately. In effect, it's simply, in my submission, erroneous to use that as a basis for joinder. So, in relation to the Spelling-Goldberg case, it needed to present a question or issue between the parties and the interveners. The mere possibility that the defendants might in future copy frames from the intervening firms if they were successful on the appeal did not give rise to such an issue. And by analogy, I'd say in this case, the mere possibility that the applicant, as a shareholder, may be affected by the winding up because it doesn't make its submissions in relation to its matter isn't sufficient. It's a possibility ancillary to the core issue in this case.
Is a shareholder 50%, is it?
A shareholder, but that's
is it 50%? Just to
a 50% shareholder. 50% shareholder, but not the party. A 50% shareholder who's able to make submissions in relation to any winding up, which is the issue. And it's not about who's at fault in winding up. What it is about is what happens to the proceeds.
all right.
If we look at the next case, which is Pablo's in the Pablo Star, I think it's worth just looking at that. And my learned friend referred to paragraph 60. If I could highlight that, it's divided two.
Next case you mean, but tab 2 or?
It's tab 2 of focus bundle 7.
Yes.
So the two fundamental criteria, or lodestars, are the policy objective and enabling parties to be heard if their rights may be affected by a decision in the case, and the overriding objective. Now, when we're dealing here in relation to the parties, it's neither the claimant nor the defendant are making an application. And when we're looking at situations, for example, in let's say usual Rule 20 matters, the defendant may want to, and your Lordship pointed out in the case of Ness, the Court of Appeal, paragraph 55, there are a number of issues where a defendant may wish to apply to join another party. That may well be because it wants to counterclaim against them, it wants to have an indemnity or a contribution from them. There's no application here, and this is going to come into the issue of consent. There's no application from the claimant, there's no application from the defendant. What it is, it's a request, a separate distinguished request by an applicant to say they want to be involved in this matter. But what do they want to be involved in? They want to be involved in a completely separate matter in relation to the detailed level of elements that put in their request for arbitration. That's not the issue before this court. And I'll be repeating that as a submission, because that goes to whether it's within the interest of justice and whether there's a particular matter that they're affected by. Following it through, if this company is wound up on the best case scenario, to what extent is the applicant able to be affected by the proceeds, disposal of the proceeds? All of the submissions that have been made about the proceeds apply to this simple assessment of winding up, without the complication, without the additional issues, and without the additional arguments that will, in my submission, be against the costs and be against the proportionality of this particular claim. And I'll be developing that when I look at the other matter. And probably, Your Lordship, won't be surprised to you hearing my learned friend's exposition of the nature of disputes that he wishes to put forward, that's not what is before the court. And if you assess and compare and contrast what is before the court and what my learned friend wants to submit is at dispute, you'll see there's a disconnect which, in my submission, undermines the request for joinder fundamentally. Dealing with your point about the interest or may be affected, if we look at the case of LB Holdings, which my learned friend also highlighted, and that's at divider 3. Now, in this case, my learned friend did summarise it effectively, but not in the context of the question you asked. It's paragraph 18. In this case, Limited clearly had a strong economic interest, and that's paragraph A. And it said that it's wanted to put its own perspective forward to rely on in order to develop its position.
Yeah.
And it said that it considered the neutrality of the administrators put forward. It put forward a number of arguments, in particular that they had a strong economic interest or affected. And paragraph 22, page 25, it was concluded by Mr. Justice Mann that there should be no joinder. He accepts that a strong economic interest exists. That's your affecting point, Your Lordship. This is paragraph 22.
Yeah.
He accepts a strong economic interest exists, but it is insufficient by itself, and do not accept the other reasons for joinder. Repeat what he said about a lack of conflict from the Holdings PLC administrators, and it was unrealistic and contrived to say that there will be one in the circumstances. It didn't rely on the point that Mr. Phillips made to extract terms of the finance document to try and make an issue that wasn't. So the point when we bring it back to this case is to the extent that the applicant has an interest, that isn't in itself not sufficient. What it has to demonstrate, as my learned friend said, is that it's desirable. Now, it's not desirable if it's not one of the issues. It's not desirable if they're going to raise new, separate and sophisticated additional legal arguments. It's not desirable if it's going to increase the cost and scope of inquiry, and it's certainly not desirable when the claimant doesn't consent to the matter.
But as a general notice, you've seen in those cases where the joinder application was refused, in most of those cases, there is a defendant already exists.
Absolutely.
and make those arguments so the judge might see there is no add value for the new defendant to be joined, or he will be raising the same point. But in our scenario, in our case, the main defendant is not available, or he's not making any defense, or he's not making any argument. This is the difference.
Well,
how we can address that?
Well, Your Lordship, I'd like to distinguish that factor, because the defendant does exist. It is a body. It is an entity. And to the extent that winding up is triggered, the arguments about the division of the spoils is live. The key here is, and Your Lordship is absolutely right, and you highlighted the real nub of this. The defendant is a body that is in situ that cannot be functional. And that's the point of the claim. It's a frustrated matter that means that it's got to be resolved in the most expedient and cost-effective way in accordance with the overriding objective. So, an argument by a separate and distinct party to seek to frustrate that expedient and effective resolution of the dispute, my submission is that it's not the same. And I'd make the point as well that the applicant isn't seeking, and the mischief of the applicant's position isn't seeking to say it wants to join to make these arguments. Your Lordship is aware the applicant seeking to join to say the court shouldn't even hear the arguments because there's no jurisdiction. And that belies their circular basis of their position. On the one hand, it's a right to join. It's right to then join to say there's all these sophisticated arguments that they should be put, which would not otherwise be put. But actually, it wants to join to say the court shouldn't even hear these matters. So that's why this is a completely separate, distinct process to the normal matters where you have a defendant wanting to join a party or a claimant wanting to join a party. This is an applicant wants to be engaged in proceedings with the specific purpose of frustrating the effective and efficient resolution of the dispute. And that, in my submission, isn't in accordance with the overriding objective, and that isn't desirable for the purposes of section regulation 20. Your Lordship, if we can deal with the matter of absence of consent, because what my learned friend is seeking to say and submit is, well, consent is effectively irrelevant if the matters of in the English courts 19, CPR 19 aren't engaged. I disagree with my learned friend in relation to that submission. And if we can look at the case of Milton Keynes.
But before we jump to the English authority, do we have any reference in the RDC about the consent? Do we have any reference here in our rules?
Your Lordship, no. But by analogy, and because RDC 20 is drafted in the same terms as CPR 19, it's an analogous interpretation I've been inviting you to accept.
Yeah, but in the CPR there is a clear provision about the consent.
No. What the elements of consent are developed is as a result of considering the provisions of Rule 19. And I'll be inviting your Lordship to consider an analogous interpretation when considering the identical provisions of Rule 20. So if we look at tab 4.
Yep.
The procedural history is set out in page 27, where there's a late application to amend to add a defendant, and my learned friend took you to paragraph 7 and 8. He didn't take you to paragraph 12. And this is the point where, firstly, paragraph 11, it says there's no matter of dispute between the council and VMW. Indeed, the council has made it plain, because there's no dispute between it, does not wish to add another party into the proceedings as a defendant. Neither was there a pleaded issue between the party and the defendant in that case. So we've got to have a look at, in the context of this claim, what is the pleaded issue. The background of the claim suggests, admittedly, that Sunteck has failed to complete its obligations. But the background of the claim, in my submission, is separate and distinct to the resolution of the claim. Whether or not Sunteck is in breach of his obligations does not, in my submission, deal with what your Lordship has quite properly pointed out, a company that's no longer able to function. And that's, again, comes back down to why this claim has been brought. Paragraph 12 says, page 29, I do not, furthermore, I consider that it would be a nonsense if a defendant could join another defendant into proceedings against the claimant's wishes in circumstances which that claimant would then become potentially liable for the costs of the new defendant. A claimant is entitled, and this is important, Lordship, my submission, is entitled to bring proceedings against parties with whom it considers that it has a dispute. A claimant cannot be forced to issue proceedings against another party. Accordingly, these amendments fail. My submission, we're in a twilight zone here. We're in a kind of an unreasonable universe, in that this isn't an application where a defendant saying, I need a contribution from this company because they're liable, or in the case of insurance, or I need an indemnity, or I'm going to have a counterclaim. This is a completely separate, independent body saying, I want to be involved in this litigation for which there's a pleaded issue of remedy against. I want to be involved in this against the wishes of the claimant, and furthermore, if that continues, there will be further costs and further issues that arise from that. And in my submission, paragraph 12 and the thrust of Milton Keynes in the context of the facts applies specifically to this case. Because the effect of joining the applicant would be to increase the issues, increase the costs, and increase the time in which this matter that's patiently calling out to be resolved is actually resolved. I think at this juncture I do need to deal with because I did get the case of Nest very late in the day. I wasn't able to have picked up on it, but I have had a chance to read and assess it, and I'd just like to make some observations that actually distinguish the Court of Appeal Nest from this the analysis that we're undertaking here. In Nest, it was the claimant, as you're aware, Your Lordship, that was seeking to join a defendant who wouldn't ordinarily, and it was found as a matter of judgment, that it was found that that third party, Mr. Fadil, the court did not have jurisdiction under the gateways to serve him. So the initial aspect was there was no jurisdiction. What the Court of Appeal found in Nest was that Justice Giles was wrong in not properly addressing Rule 20 on the basis that there was no jurisdiction. And my learned friend has correctly summarised the fact that the Court of Appeal found that Rule 20 provides another gateway to allow parties to be added in appropriate circumstances. But in Nest, it was the claimant that asked the parties, to the defendant, to be joined, and that's completely irrelevant to the facts of this case, where the applicant in this case does not consent. It was also relevant in Nest that there were public policy reasons for the Rule 20 to be expanded. Now, they're set out quite effectively in paragraph 55, 56 to 58 of the Court of Appeal judgment, which no doubt your Lordships are fully acquainted with. And we've already made the point in Nest, it was already decided that, and it's almost inverse to the process in this case, your Lordship, that the defendant who they sought to add did not have, there was no jurisdiction. So there was an initial decision that there was no jurisdiction, and then there was an application to add. Here, there is no, in my submission, we're doing it in the right way. The first is, should it be should be added, but in order to look at whether the person should be added, it's necessary to consider the issues that are involved in the case. And the issues involved in that case was that Mr. Faddle was effectively the operating mind of the auditors. And as the operating mind, whether he was called as a witness or not, it's likely that the main defendant, auditor, would have been held vicariously liable or otherwise as a result of his actions. So he was crucial, central to the determination of the issues which made it appropriate for Regulation 20 to be engaged. Here, there's no need, no requirement, or no effect for the applicant to be engaged in the narrow confines of this dispute between the claimant and the defendant. And finally, in relation to Nest, what the applicant is seeking to effectively do is say that it should be joined as a matter of jurisdiction under Rule 20 to then say that the court doesn't have jurisdiction. And in order to do that, in my submission, it's trying to stand in the shoes of the defendant. It's not yet a defendant for the purpose of Part 12. The defendant needs to make such application, but your Lordship's right, it's not in a position to do so. So the point here is the applicant is seeking to ignore whether there is jurisdiction or not, or even a claim, because if there's no jurisdiction, there's no claim, to then be added. Now, if we can break that down, when we're looking at the overriding objective of dealing with claims and use of court time and resources, what the applicant can't do is stand in the shoes of the defendant. And what it's seeking to do here is say, we understand there's no defendant, but let us be added, let us be taken in the place of the defendant, and let us then say there was no claim. So it's taking it effectively from saying that there's, for the purpose of the application, there's a substantive claim, but at the end of the application, it's going to be arguing there's no substantive claim. In Nest, Lordship's fully aware, there was a fully valid, fully pleaded, and fully able to proceed substantive claim. And the circularity of the applicant's approach in this regard should be avoided.
Now, do you think if the defendant decided somehow to be active in this case and represent itself or made those arguments about jurisdiction or whatever, do you think then the applicant will apply to join the proceeding?
Well, the applicant's a separate, distinct body.
If we have in another scenario a defendant who already, been given instruction to lawyers and they engage in the proceedings, then I'm in the perception that we wouldn't see that type of application for applicant to join the proceeding. I made those arguments about jurisdiction or any defense.
The defendant would be placed to make those applications.
Yeah, I mean,
as the defendant.
So the question, if we have active defendants making those arguments and defense, then it is unlikely to see this type of application for applicant to join the proceeding.
Absolutely.
This is right. This is fact.
But your lordship is in my submission, overlooking the process here is that we don't have an active defendant, and we don't have an active defendant, and that's the reason why this claim is being made. Why we want to ensure that the proceeds are properly and effectively distributed as effectively and efficiently as possible. Had there been an active defendant, the question is whether there would have even been a need for litigation, because it may have been operating in accordance with the principles. But there wasn't. And dealing with your point then, therefore, that because there's not an active defendant, it's somehow appropriate or desirable to allow an applicant to stand in the shoes of the defendant and make the arguments that the defendant would otherwise be able to make. My submission, that's not desirable, because the applicant isn't making the submissions on its behalf. It'd be making the submissions on behalf of the defendant. And more importantly, its dispute, which it's so eloquently pointed out, is the subject of arbitration proceedings within Singapore, which is able and is proceeding with. So there are separate and distinct factors, and my submission is really necessary to ensure that the dispute that you are considering isn't the dispute that my learned friend is seeking to invite you to deal with.
Okay. Second point.
If I can now, my learned friend set out or laid down the gauntlet for me in relation to his submissions by saying effectively, it's for me to establish why it's not desirable for the applicant to be joined. Well, there are a number of reasons why it's not desirable. First and most importantly is that the dispute that is being considered is confined, and to allow the applicant to be joined would to expand the scope, cost and time in which the matter can be dealt with. Second is in relation to the wishes of the claimant. The claimant is clear that it does not accept the application, it objects to it, and does not consider it to be an appropriate use of court procedures. Third is in relation to the scope of determination. The applicant has a full and arbitration process that it's running, which is a separate consideration. That's a claim that it's making against the claimant. That isn't the applicant and the defendant. And if we look at the case of XYZ, that's page divider 6. In this case, there was a number of claims in relation to breast implants. There was the manufacturer, there were hospitals, there were nurses, all of which had separate insurance companies. The claimant decided who wished to claim against, as it was its right to do so, in accordance with the Milton Keynes case. It's the claimant's remit. It can decide, stand or fall on the claim it wishes to make. One of the insurance companies, and again it's inverted to this, wanted to join another insurance company, and that wasn't permitted on the basis that it wouldn't have been in accordance with the overriding objective. Now the question I'd ask, and just discursively in these contexts, what would be the position if the claimant sought to bring a claim, albeit ill-advisedly, against an insurance company without funds? Would it be then appropriate for another insurance company that somehow supported the first insurance company to then apply to join to be part of the proceedings, even if the claimant didn't want to do so? In my submission, the answer would be no. The answer would be no, because the claimant has to stand or fall by the claim it wants to break. And the fact that another party has interest is not in itself sufficient for the court to undermine that as a process. And in this case, my learned friend pointed out paragraph 27 of the case, page 65, that however attractively packaged the application may be, is an attempt by the insurance company to establish in advance the depths of another insurer's pockets. Mr. Lockle's submissions are correct. They would entitle a claimant in personal injury case to join proceedings at defendants' insurers seeking declaration as to the scope of the insurance available to meet the claim. And this is about the identity of the parties to any litigation. And it is, as Milton Keynes' case says, down to the parties, that is the claimant and all defendants, the case may be, to assess the scope and remedies of the claims. If I can deal just in a bit more detail with the my learned friend's submissions about the scope of the dispute. In Divider 1, in Volume 1, we can see the state of the illiquidity of the defendant. Mm-hmm. And if I just take you through those.
Volume 1?
Yes, yes, Your Lordship. That's, so if we look at Volume 1 first, at the tab 5. Where is that Volume 1? No, Volume 5, sorry. Volume 5. It's Volume 5.
Okay. Volume 5. Tab.
Volume 5, no, it's tab 7. Actually, my trial balances.
Witness statement?
Yeah. Tab 7, and if we look at pages 61 to 62 first. We see the trial balance at 61 to 62 of a 3.34 million AED liabilities. You see a third of the way by the first hole punch as current liabilities. Mm. That's 3.24 million AED as at August 2015. If we can go to page 64, 65, we see again in the same part of the third, the first bullet, the first open, That's 8.456 AED liabilities. And if we can look at the page 134,
Page, sorry.
134. We see there that the 134.
It's not 134. 3912. Sorry,
19.4.
Yes.
8.92 million as at 2016. You follow that through to page 285. 285 and 286. Was that right? No. Not on the right page. Oh no, we go back now. Actually, we go to volume 1 now. Sorry, we go back to volume 1 and tab 24.
Yes.
And we have here the audited accounts at page 285 and 286. And this is 2017, 19th of March,
Yes.
where it states at page 286, paragraph C, that the claimants contributed 245 million AED and the applicant had contributed 19.4 million AED. This is the auditor's accounts at that stage. And at page 287, you can see as at 31st of March 2018 that the liabilities have now increased to 61.1 million AED. Now, my learned friend made the point that there is a esoteric reference to contractors to establish the liabilities in this context. But what my learned friend can't do is challenge the fact that just to exist as a company, there would be needed to be licenses, fees, municipality fees, and matters to progress. And for my learned friends to simply say that the company ought to have existed without any income or any matters is belies what the contract actually says. So put it in that context. This is a company, the defendant company, has significant debts. There's no way in which that is going to be resolved, save for the dispute, as has been suggested in the claim, for the company to be wound up. And all of my learned friends' sophisticated arguments do not address that point about what happens to this company and all the interest he seeks to apply to a completely separate claim to the one that is before the court. And in that context, we need to assess, my submission, whether the applicant in this case, when I've said there's a difference between the defendant and the applicant, well, the applicant in this case is a primary party or a secondary party. And the XYZ case that has been referred to highlights the fact that secondary parties, those with strong interests, but against the overriding objective, is not sufficient. They're still secondary parties. And that is in my submission, the basis of the applicant's challenge for joinder here. It's a secondary party. It has an interest, as you found, under the Rule 36, but it doesn't meet the necessary criteria that is required under Rule 20. So, in summary, in relation to the joinder application, it's my submission that the application must fail because the elements of Rule 27 in relation to the desirability of dealing with the issues in accordance with the overriding objective, in accordance with what the applicant seeks to achieve, are not supported. The fact that the primary focus of the applicant is to argue, wants to be joined to argue there is no jurisdiction, my submission undermines its application in this context.
And what's wrong with that?
Because
it's part of the benefit. What's wrong with joining the proceeding to challenge the jurisdiction? I didn't see why this is not sufficient.
Well, under Rule 20, Lordship, the analysis has to be, it's not necessarily to be joined to argue a point of law. We've got to be joining in my submission to effectively deal with the issues in dispute. And the issues in dispute here are those between the claimant and the defendant. What the applicant...
Who represent those issues in dispute? The issue in dispute so far being represented just by the claimant. We haven't heard from a defendant what his view on the issue of dispute. Right?
And your Lordship knows exactly why.
No, I'm following your argument. Yeah. We haven't heard from a defendant what is the issue in dispute.
And
so the claimant say the dispute, the issue in dispute, ABC. The defendant has no any view on this. So we have a party who want to join this proceeding because there is interest in joining this proceeding to raise the issue in dispute.
Well, your Lordship, I do have a significant issue with that, and that then comes to the identity of the parties. If a party is insolvent or unable or doesn't put in defence for whatever reason, does that then entitle another party to run that person's defence for them? And my submission, it's no. Because there are court procedures for default judgments in certain circumstances. If a party is unable, unwilling, or not engaging in the process, there are court processes to deal with that in respect of that party. And what your Lordship has posited as a question is, to what extent then can it be an appropriate process for another party to stand in the shoes of a party that cannot, will not, is unable to engage in court processes? This isn't about...
but this is not like a strange party. This is a party who has an interest in the defendant company, 50%.
Well, one of that then goes again to the...
So it's not like a party who just came from nowhere and they want to join the proceedings.
Well, it's a secondary interest. It's not and this is where I'd ask you to carefully consider that interest secondary to the dispute. That 50% shareholding is there, it's still there, and it still will come out in the wash. That's not affected. It's respectively almost like a brother appearing on behalf of another brother. It can't be done as a matter of court. So, well, that brother lives with me, therefore I want to act on his behalf. No, that wouldn't be an appropriate way in which the court processes could be undertaken, notwithstanding the fact, for example, if the particular person doesn't engage. So it's my firm submission that there's got to be clear water between the nature of this claim and the interest which your lordship is saying it is entitled to, that interest is still live, but it's not related to what this court can do in relation, or connected to what this court can do in relation to the determination of the dispute. Now, I can see your lordship is concerned about what's the issue about having another party, but my firm submission on that is that other party does not have the locus or jurisdiction to speak on behalf of another party, or to raise those arguments for on behalf of another party. There are elements in other jurisdictions where there can be an independent order from the court. For example, if it can involve, for example, tax authorities, if a court identifies that another party could be affected to the issues in dispute, then the court can make those orders, or a party can try and apply to intervene. Here in this case, the shareholding, the 50% shareholding, does not, in accordance with Rule 20, give your lordship the basis for joinder. What it does do is, and you've already found, is it allows them under Rule 30 to be considered as Rule 36 to be considered as having an interest, but that's not in itself sufficient for the consideration of Rule 20. And so the point I'd make about that is have a clear demarcation between the interests and objectives of the applicant and the inability of the defendant to participate. And just making the point that my learned instructor solicitors has made, and it goes to the submissions I've been making about what the disputes. All of the matters which may concern you about this interest are there in the arbitration proceedings. The applicant is not in any way able to be undermined to the extent that it's got a claim against the defendant, against the claim. It can do that in the arbitration proceedings should it feel appropriate. That is a separate, distinct process. It's not in accordance with the overriding objective to be dealing with what I'm saying, because they're completely different issues, they're completely different processes, and don't overlap in relation to.
This is very area estimation. The applicant didn't file a counterclaim against. This is something can be dealt with in that process.
No, it hasn't. But what it has done is it's able to protect its rights, as it is doing, in accordance with the arbitration proceedings. So that's another significant reason as to why it's not in accordance with Rule 20 to allow, because then you're going to have duplicated proceedings. One, to consider the jurisdiction and the issues within this forum, which the claimant says is irrelevant, and the other more extensive, expansive issues which my learned friend wants to raise against the claimant as a respondent to the request for arbitration. They're separate hats and should be seen as completely separate.
Well, I don't want to argue the jurisdiction point. I'm just thinking loudly. Let's say if, and it's only if, the court decided to allow the applicant to join the proceedings, then they dealt with the jurisdiction, and the court found later on there is no jurisdiction and dismissed the claim. So still the remedy is available for the claimant to seek that declaration or winding up from the local court, from Dubai court, let's say. You know what my scenario here. So what's wrong with that strategy? Or how the claimant will be, let's say, will not get what he looking for if this claim has been dismissed on the jurisdiction point and approach the Dubai court for winding up process against the defendant?
The claimant would have to make separate proceedings. And
but that proceeding is available, that remedy available outside.
and without getting into the jurisdictional argument, the
No,
claimant
I'm
claimant
just-
says
let's say
that's
put
what,
that
it's
scenario.
done, that's what it's done properly here.
Yeah, but that remedy will still exist over there outside the DIC.
That's
right?
a potential remedy, but the claimant's position is that remedy is available here.
I understand the strategy of the claimant. He chose to follow with this strategy or this remedy rather than the other remedy which is exists outside. But this is where it's my thinking, but I'm not going to decide on this. As I said, I'm not deciding on jurisdiction or whatsoever.
Well,
I'm just following the scenario for the claimant.
Your Lordship makes a valid question in relation to that, but I think it would be right and proper for the claimant to be given a full opportunity to deal with that in relation to a composite application dealing with jurisdiction as a separate and distinct matter, including the matter you raise about what the prejudice is, if any, to the claimant, and that may be the need for witness evidence from the particular directors, which we don't have before this court. So the fact is, my submission, that would be a matter that, as my learned friend pointed out, if the court ordered or directed for that to be dealt with in relation to the issues of jurisdiction, the claimant would properly deal with that. But it hasn't come with appropriate witness evidence or appropriate submissions to deal with that today.
Right. Yeah. Any further points?
I'm grateful.
Thank you very much. So the applicant has 10 minutes to comment.
I'm sorry, I hope I won't take the full 10 minutes, but I'll see what we can do. What one has seen very skillfully from Mr. Berger and other friends is an attempt to redefine what are the issues in these proceedings, in the GIC court proceedings.
Yes.
And he's done that by saying, well, look at the relief source and look at these declarations. But actually, when one looks at the brief details of claim, what is claimed in these proceedings, it's entirely clear that what is said is that there are breaches of the duty to make financial and non-financial contributions, and that as a result of those breaches, the JV company and the project essentially has been frustrated as a result of the breaches by Sunteck. That is what is claimed. He could have taken some technical point that there hadn't been a joint of issue because there hadn't formally been a denial by the joint venture company. I'm pleased to say he didn't try and go down that route. He sought to identify the issues instead by the declarations it sought. But the issues in any case is what you need to prove to get to the relief sought. It cannot be said that the pleading of the alleged breaches is just some part of the background or part of showing the intention or the motivation for seeking the winding up sought. You plead a case because, by definition, that is what you need to establish in order to show your entitlement to the relief sought. That is the definition of a pleading. It's the definition of the brief details of claim, of the particulars of the claim. And that is why they've gone to the trouble of alleging those breaches of the contribution obligations under the joint venture agreement. Now, it's said that what the secondary suggestion is that somehow it would be cost-effective or convenient for everything to go off to the liquidator. Don't worry, Lord. Actually, although we pleaded these issues about contribution, you don't really need to go there because it can all go off the liquidator. There'll be pain-free decisions as to whether there have been, I think it's the divvying up of the assets, and we don't need to worry about all of these difficult claims about failure to make contribution. Well, my lord, that simply doesn't work. What you're then going to have is you'd have the contribution, failure to make contribution, breach of the JVA allegations being decided in the Singaporean arbitration, because they are raised squarely in the arbitration, in the Singaporean arbitration. And inevitably, the liquidator...
But not against the defendant.
Exactly. And inevitably, the liquidator would be required to resolve disputes about whether parties have made contributions, whether parties should have paid for these various contractors or professionals. So the very same disputes would then be required to be resolved by the liquidator. Inevitably, those disputes in the liquidation would then come back in the DIFC court. So rather than having a means of resolving the issues between the parties that is cost effective, you'd have a means of resolving the disputes between the real parties in a way that is entirely duplicative and extremely expensive. So there is no pain-free resolution or divvying up by the liquidator without hearing these disputes. We say these disputes should be heard between the joint venture parties in the Singaporean arbitration. If one looks at the arbitration proceedings, those issues are fully canvassed in our submission in those proceedings. And we say that is how matters should proceed. It was said curiously that the matters in the Singaporean proceedings are completely separate as claims. I just wish to, in that respect, look briefly, and I'll try and be brief given your 10-minute indication, at the response, which your Lordship has in Bundle 5 behind tab 7.
Yes.
And this is the response. If I could take you very quickly to page 302, bottom right-hand corner. I'm just going to start by looking at some headings, just so we get an indication of what is being alleged.
My Lordship, I'm very concerned about this line. Bear in mind, arbitration is supposed to be confidential. We will actually open the water if my own friend is going to refer to the request for arbitration.
Miss Sheffield is in it.
Well, I'm concerned because there is a request for arbitration, and the arbitral proceedings are supposed to be confidential for the purposes of consideration. If my learned friend is going to refer to them, obviously they'll report that.
This was part of your submission or
my learned friend's.
It's an exhibit to Miss Sheffield's fourth witness statement.
that was exhibited already?
So it's been exhibited.
Look.
So the headings, number 4, section 4, invalid invocation of the arbitration agreement. So it's been said that the tribunal, the Singaporean tribunal, has no jurisdiction. So jurisdiction of the Singaporean tribunal is being raised. And then over page, the heading at the top of that page, preconditions to arbitration not met by the claimant. So again, that's a suggestion that a tiered procedure and the arbitration provision hasn't been duly followed. These are all of the issues as to jurisdiction which could have been raised in the responsive evidence in these proceedings, but which haven't, but which are fully canvassed, we say, in the arbitration proceedings. But for my purposes, I want to look at the heading at the bottom of page 303, beginning of paragraph 410. Moreover, it would be premature for this arbitration to proceed until a final conclusive DIFC court judgment is issued in respect to the second DIFC court proceedings. So it's being conceded that there is an overlap between the arbitral proceedings and these proceedings. And then paragraph 411, there's a risk that if these arbitration proceedings are allowed to continue while the second DIFC court proceedings remain ongoing, the relief sought by the claimant in its request could produce a result inconsistent with the finding of the DIFC court on the same issues. And then the allegation as to the priority of the DIFC court proceedings, 412, as the second DIFC court proceedings were initiated first in time, a further advance in this arbitration, and have the active participation of both parties on matters overlapping, the relief sought by the claimant in this arbitration. These arbitration proceedings should not advance until a final conclusive judgment is issued by the DIFC court. So an acceptance that these are essentially the same issues that it's seeking to advance here as in the Singaporean proceedings. So that is my first point. There is no cost-effective, as my learned friend sought to suggest, means by which we can just kick matters off to a liquidator on the basis of solvency, and on that basis make matters much more cost-effective and much more efficient. And I think it was suggested that the basis on which those matters could be kicked off on a separate review was that one could treat it as a matter of balance sheet insolvency. Looking at the trial balance sheet, is this company insolvent? We can avoid all these nasty disputes about breaches of the JVA. Now, it's interesting in that regard to have a look at what Ms. Sheffield says in one of her earlier statements, I think her third statement. If one is behind tab 7 in bundle 5, and if one looks at page 46, so this is Ms. Sheffield's third statement. Financial position of the JV company, this is paragraph 7. So Mr. Braganza has denied that the joint venture company is insolvent. As reflected by the trial balance sheet exhibited at page 30 to 31, the joint venture company is a shell company with only one asset, namely the plot, which was transferred to it by the claimant respondent, such that it's entirely reliant on the contributions made by the JV parties. Now, what my learned friend then took you to various balance sheets, which were pre-July 2015, i.e. pre the transfer of the property. The property was supposed to have been transferred in August 2014, but was transferred nearly a year later, in July 2015. So if one looks at those balance sheets, so for example, the one to which my learned friend, or to which Ms. Sheffield refers there in paragraph 8, so pages 74 and 75, bottom right-hand corner.
For which year? 2000 and?
Well, let's look at page 75.
The top of the...
Sorry, yes, exactly. Trial balance June 2014 to 31st March 2015. And yes, you see various current liabilities to sundry creditors, but that's before the transfer of the property. So we know that after the closing date of that trial balance, the property was transferred, we say in breach of contract, a year late. And so what one therefore has in terms of balance sheet is a company that has various ongoing liabilities to various professionals and contractors, but which is still balance sheet insolvent because it is the owner, as Ms. Sheffield accepts in paragraph 8, of the one asset, that's to say, the plot. And I don't think I've yet heard it suggested that the accrued and continuing to accrue substantial liabilities to creditors in any way will come close to exceeding the value of the plot. So balance sheet insolvency is not a shortcut to just saying, well, we can kick off anything difficult to a liquidator, or indeed that the liquidator can just have a convenient giving up of the assets, and that's all it needs to have. And finally, in conclusion, oh yes, sorry, I should deal with the suggestion that the Milton Keynes case suggests that only the claimant can bring or can apply for the joinder of a new party. As my learned friend accepted, the joinder is, in the old regime, pre the CPR, used to be called intervention. So you had an intervener, and it was implicit in the idea that a party is intervening in existing proceedings. That they were a non-party who, by its own initiative, was seeking to intervene in those proceedings. And if there was any requirement that the application to join a new party should be made by either the existing parties or indeed by the claimant, as suggested in the more extreme submissions of Madame, the very least one would expect is that that would be reflected in the carefully drafted wording of RDC 20.7. So we say that as a matter of law is a thoroughly bad submission. And my last point, really, by way of submission, is my learned friend appears to accept that we have a sufficient interest, or Sunteck has a sufficient interest for the purposes of RDC 36, but does not have a sufficient interest, or has no standing for the purposes of RDC 10.7. The irony, we would say, in that submission is that the test under 10.7 is a broad test of desirability, whereas the test in RDC 36, in terms of whether a non-party can intervene, is a much more defined and honed test. And so we say, by reference to the broader test under 10.7, it's very clearly desirable, and that therefore that's the basis of our saying that if we were right in saying we could intervene under RDC 36, we say similarly we're right, it's desirable that we should be joined to protect and defend the interests of the joint venture company. Yes, and I just would finish by reasserting what I said, that there is a separation between the claims which are in the arbitration and which should be dealt with in the arbitration, and which are canvassed in the pleadings to the arbitration, and the ability of the UA court, pursuant to such declarations as may be made by the tribunal, to give the relief that should be properly given by the UA court. Those two are not exclusive. That, we say, would be the appropriate course.
What is the status of the arbitration claim in Singapore?
Well, you have, if I could check you briefly.
No, just that briefly. Is it still ongoing? Or
Yes, it's ongoing. We have it's fairly recent, the date of the response. It's quite. There's a case management conference in the next few weeks. So we have, is the tribunal constituted? The tribunal has been constituted.
And of course, the defendant in this proceeding, in this case, is not part of that proceeding.
No, because it's between the parties to the JVA.
And not being added or joined.
No, and I don't think it could as a matter of arbitral law. You need to be a party to the arbitration agreement. Yes, the response is the 26th of December 2018, so one can understand why 4 months later, we would now be in territory of a case management conference.
Would you like to more comment on the remedy set by the claimant, where it is related to the applicant in this proceedings, how that related to the applicant? The remedy sought by the claimant in terms of declaration and breach of contract, GB, because the applicant did not pay or did not pay his shares and his contribution to that GB. Is that my understanding, or this is something?
Well, yes. They say that they want. Well, initially it was implicit that they would actually want a declaration that there had been breaches of the joint venture agreement, specifically the funding obligations under the joint venture agreement. I think the sort of subtle shift in today's submissions was just suggesting that the declaration was just and set out in the relief, and that somehow the allegations in respect to contribution were there by way of background. But in our submission, it's entirely clear that to get to the relief sought.
Alleged breach of the GB, that was is there any suggestion that caused by the applicant because it's a shareholder in that company, or?
Yes, precisely. The alleged breach is by Sunteck, and that is said in terms in the brief details of claim. One sees continual reference to the fact that it's Sunteck which is said to have frustrated the joint venture agreement, frustrated the activities of the joint venture company by its failure to provide funding.
My thought is, how come that type of remedy or the allegation is not relevant to the applicant in this proceeding to join this case?
We don't understand. Clearly it's an allegation that's being made essentially against us and contrary to our interests.
Or suggested in the remedy somehow that there is a need to declare that JV is cancelled or dismissed because someone's fault, and
yes.
that someone's fault is Sunteck.
Exactly. So in order, the winding up is sought precisely on the basis that, well, the joint venture company is being frustrated, it is in deadlock, and the reason it's frustrated is because of the alleged failure by Sunteck to provide the funding that would be needed to take the joint venture forward.
I would like to, if you want to comment on
absolutely.
before we
this causation which you've highlighted forms no part of the claim form. If you can go back to the claim form.
the remedy.
Yes,
Yeah.
and there's nothing in the declaration that says, if we look at page...
So just let me go through it by detail.
It's tab 9,
Tab 9.
and in volume 1.
Volume 1?
Yes.
Tab 9. Yes.
and the remedy sought. And this is the point of relation, the distinction which I make between background, where my learned friend will say you can't have background as part of the pleading. What we're looking at in remedy sought, there's no reference there because of what it says. It seeks declaration for the dissolution, no fault is ascribed, and is entitled to interest. First defendant, no fault is ascribed, and is entitled to defendant's process. So the analysis that it's in the declaration is we're entitled to this because the applicant has done that isn't what the remedy is sought. The remedy sought is this JV is frustrated and we need it to be wound up. And it is patently not, in relation to members sought, a declaration for any fault to be ascribed or even absolutely any reasons for the basis for it to be ascribed. It's simply seeking dissolution of the matter. That's the claim. That is the full scope of the claim.
Thank you for clarifying.
I have to rise briefly on that. If one looks at the brief details of the claim, 4, the claimant Sunteck entered into partnership. The claimant has adhered to its financial and non-financial obligations. Sunteck has failed to adhere to its financial and non-obligations. Claimant's partnership has been frustrated. 7, in the circumstance, the claimant seeks the orders from the DFC set out below. So the relief is expressly and in terms linked to allegations as to the fault and non-fault of one party and the other under the joint venture agreement.
All right. Thank you for both of you. My judgment in this application to join the proceedings is reserved to be handed down in maximum 3 weeks, taking into account the Ramadan time. In terms of the jurisdiction application, I decided not to hear this today, and I will address the reason why I'm deciding this in my judgment. But as a simple reason that, in my view and my understanding, the applicant not yet a party to this proceedings, and once the court decides on this, then he can be submit any application in terms of jurisdiction. Cost will be decided as well in general principles when I deal with my with the application to join this proceeding. Thank you for both.
My Lord, could I just make one point, which is if your Lordship were to find, I don't wish to repeat if your Lordship were to find that we should be joined and that issues of jurisdiction should then be decided, we would seek a very a detailed timetable in terms of making sure that jurisdiction is resolved quickly. We do say that the claimant, Grand Valley, has had 5 months to prepare its case on jurisdiction, and we do say, if one looks at the response in the arbitration, that all of the issues on jurisdiction are already canvassed there. So we would say they should have no more than a month.
Well,
and we would then respond in a month. But we'd say 2 things. First of all, it needs to be a rigorous timetable, and secondly, we would say that the claimant should go first in explaining the basis why they say there is jurisdiction, in circumstances where they've yet to identify even again. But my Lord, that's a hypothetical at the moment.
Yes. Your Lordship, that simply doesn't work as a matter of process. Any applications that we made have to be made on behalf of the applicant, on the part of our application. So, if there's going to be any orders, it's going to be for the applicant to make an order, an application, and for the claimant to respond in the usual way. And there cannot be any shortcuts that are suggested in relation to this matter. If there's going to be applications we made, that's be made in the appropriate way.
all right, thank you. I've heard both sides comments on this. I will deal with it in my judgment. Thank you very much.
All right.